now, what's the special monitor here? Is there a list of qualifications he has to have?
I don't believe the statute contains any list of qualifications, no.
So can the
I should say the proposed
can the governor
legislation.
appoint somebody, say, with a degree in political science?
Again, I don't believe there's a list of qualifications in the proposed legislation. You know, I think it would be in the governor's best interest to appoint somebody who was experienced in dealing with criminal law and dealing with those types of matters, because you know, I would think that the governor would want a qualified person to make the best possible recommendation in a very serious situation like this.
Okay. And now, currently, in order for you to take a look at grand jury testimony, the only one that can release it is a judge.
Correct.
And what we're going to do in this case, we're going to keep that protection for anybody else that's in front of the grand jury. But if it's a police officer, we're going to get rid of that. So we're going to treat police officers differently than anybody else that's under a grand jury investigation.
The proposal would not allow for public release of the minutes. It would allow for release of the minutes to the monitor only.
Okay,
At least that part of the proposal.
and the judge doesn't have to approve that? Or a panel of judges don't have to approve that?
Not to the monitor, but the
Okay.
monitor can't publicly release it. So, you know, under no circumstances are going to be, with that part of the proposal, is there going to be public release of the minutes.
Okay, and now what's happening is, for some reason, the newspapers come out, they don't like what the grand jury decided. So what the governor's going to do is get a second bite at the apple for the grand jury, right, through this monitor, and say, let's make the public happy, and it's a great political move, so let's put it in front of the grand jury again. How many bites at the grand jury apple are they going to get? Is there any limit? So if they don't like the second result, can they put it in for a third result, or a fourth result, or a fifth result, until they get the disposition that they want from the grand jury? Is there any limit to this?
Right now, under current law, if you have a case that falls within this type of case, the governor could appoint a special prosecutor with no standard articulated in law as to what criteria has to be met before that appointment. That special prosecutor could go to a judge and ask for permission to represent the case to a grand jury, could get permission, and the case could be represented. As I indicated before, I know the District Attorneys Association issued a public statement indicating their support for the concept, and I think one of the reasons for that support is that this provision provides a structure so everyone knows ahead of time what the standard is that has to be met before there's a recommendation of a special prosecutor and there can be a second bite.
Yes, but if they don't like the result the second time,
There's no provision for the appointment of a second, third, and fourth special monitor. But
is there any provision
time.
prohibiting it?
It authorizes the appointment of a special monitor one time.
Okay, and that language is in it. Last thing, the youthful offender. You're talking about violent felonies. So you're talking rape in the first degree? Are you talking about murder in the first degree? Which crimes?
Now, murder is not eligible for youthful offender.
Rape in the first degree?
Rape in the first degree currently, under current law, is eligible for a youthful offender only if a judge makes a finding that there are extenuating circumstances or mitigating circumstances that would justify the imposition of youthful offender status.
And we're going to take that away from the judge and give it to the prosecutor.
This proposal does not change current law in that regard.
So what's the purpose of it if it's not changing current law?
With regard to rape in the first degree, as I understood your question, was can the judge give youthful offender status on a first-degree rape? And the answer is, under current law right now, yes, they can, and under this proposal, it would be the exact same finding that would have to be made. Two things significantly that will change with youthful offender. Right now, you can get youthful offender 18 and under. This will extend the possible group of people eligible for youthful offender protection to 19 and 20. And secondly, right now, under current law, if you get youthful offender adjudication, that adjudication can never be used again as a predicate felony offense. Under the proposal that the governor has put forward, if you're adjudicated a youthful offender on a violent felony, and you go out and can commit and get convicted of a second violent felony, that youthful offender adjudication can now be used as a predicate violent felony offense, and you can be sentenced as a predicate violent felony offender for that second crime, something that you cannot have happen right now under existing law.
So what we're pushing, the ages up to 18 and 19 for youthful offenders, is that what you're saying?
Right now, it covers 18 and below. This will include 19 and 20-year-olds.
And just so we're clear, if you're talking first-degree rape, that would be a 19-year-old, right, engaged with someone under 10 years old.
First-degree rape, that would be one way. The most common way is a forcible rape. I can tell you, I was a prosecutor for 25 years, and I don't remember one case in my 25 years where I saw a judge find those mitigating factors and actually give someone a youthful offender on a rape. The more common scenario we deal with, maybe a burglary,
First-degree burglary?
Murder, you're not, well, first of all,
first-degree burglary?
I'm sorry, what?
First-degree burglary?
Again, that would depend on the burglary. If it's first-degree burglary and it's an armed offense, they would not be eligible for youthful offender, again, unless the judge found mitigating circumstances. That's current law, and that doesn't change going forward.
Okay, arson too, right? Would be covered under this.
Again, the current law for arson in terms of who's eligible and not eligible for youthful offender, the only way it changes is the ages. It doesn't change the criteria in terms of when you're eligible and when you're not. So the criteria that applies today, if you decided to adopt the governor's proposal, would continue to exist after that became law. The only thing that would change would be the two things I mentioned. The age would go up so that 19 and 20-year-olds would be eligible. And secondly, if you get in trouble again and commit another violent felony, your youthful offender going forward could be used as a predicate, which cannot happen right now under existing law.
Okay, thank you. My time's up.